So you're saying over time, over the last 150 or 200 years on a federal level, that our courts have kind of made it more comfortable for themselves.
Well, you know, and that confuses people too, because we have a federal court system.
Correct me out. I mean, straighten me out if I'm wrong.
No, you're right.
I want to throw that out there because I want to understand how the process is developed.
In the federal system, the founders that gave us our system of 3 branches of government chose to make our federal judges, basically the United States Supreme Court, appointed and then confirmed by Congress, but appointed by the President, not elected. So we've never elected a Supreme Court justice to the United States Supreme Court and never will.
Okay.
The same is true on federal district court levels. They're appointed by the President and confirmed by Congress. But in the state of Minnesota, they specifically chose that we're not going to have a system where we're going to have the governor appoint judges. No, we the people are going to always elect judges. Now you might say, but how come it seems like all judges are really appointed in Minnesota and rather than elected, which is the case? That's because in practice, 95+% of our judges came to the bench for the first time through an appointment system, because the election system really, even though we have a constitutional right to it, has been meaningless because candidates couldn't talk about what they believed, and they couldn't tell people what they stood for, couldn't even tell the people what they believed the law meant until 2004. That was the first time that the United States Supreme Court said to the Supreme Court in the state of Minnesota, change your system. Your Minnesota Constitution gives the people the right to elect their judges. That means meaningful elections. And you can't take away the meaningfulness by having all these rules that restrict what judicial candidates can say. So anyway, since 2004, which is the first time I started running for the state Supreme Court, now we can come and tell the people what we believe the law says. And we can tell the people what we believe. We don't prejudge cases, but we can talk to the people.
We talk about principle.
Principles, right.
Well, I want to just bring up a little quick. Talk about, if you would for a minute, this whole business of church and state. And we go back to and you and I have talked about our founding fathers and their religious and spiritual heritage. We've talked a lot about, between us, about the Federalist, Anti-Federalist papers and the different people involved in developing our country. Could you talk for a minute the pros and cons of having a godly judiciary, godly judges, people who will adhere to the law versus people who have agendas, and how our founding fathers kind of thought through that process when they set up our judicial system?
Well, I like to use the term, it's almost politically incorrect to say it now, Tim, but it used to be, not too many generations past, where we would say we want a God-fearing man or a God-fearing woman as a judge or as a legislator or as a president or governor. Well, we've kind of lost that understanding of what God-fearing means. But what God-fearing means is self-governing. In other words, if you submit to the authority of God, then you're probably going to be more likely to submit to the higher authority of the people. And you want a man or a woman on our courts that are going to submit their will to the will of the people as expressed through the original intent of the Constitution. People say, well, what difference does it make what your religious belief system is, whether you believe in God or not? Well, it makes a big difference, because every time I decide a case, Tim, yeah, I have the law and the facts, but there's going to be some discretion. There's always going to be some discretion, first of all, in determining what the facts are, discerning the truth. What are the true facts as I'm listening to the evidence? The other discernment is going to be, well, what does that law mean? And, am I a man who's going to submit his will and his ideas to the will of the people as expressed through the legislation? Again, every judge that is going to decide a case has to decide those discretionary issues. And the way you're going to do that is through your worldview. So every judge, whether you're a believer in God or not, is going to look at everything, whether it's the law or facts, through a set of glasses. And that set of glasses is your worldview. Every judge has one. If you have an atheist judge, he or she still has a worldview. It's just that worldview says there is no God, and therefore there is no truth, and truth can be whatever I choose it to be. That's what you're going to end up saying. But if I believe that there is a God, and He has spoken, and He has established absolute truth upon which law is based, then I'm going to use my discretion in a way that's consistent with my worldview. So every judge is going to have a worldview,
It
every
can't
judge.
be avoided. You're telling me
is.
it can't be
Absolutely.
avoided.
Can't be avoided.
Your views, how you look at life is going to reflect somehow in the way you look at a case.
Every judge has a worldview that's going to impact the decisions they make because there's always going to be some discretion.
And that can't be avoided because that's the nature of human.
That's the nature of man. Exactly.
Okay. Could you describe real quickly judicial activism and how it's unconstitutional? Because we're going to go through a couple of these different descriptions of words, and one of them is judicial activism. And so I want people to understand what these concepts are when they're having discussions or hearing something on the TV about a judge's ruling or whatever. I'd like them to so let's start with judicial activism. How is that related to the courts and unconstitutional actions?
Well, it's kind of interesting, that term judicial activism, and I believe that that's a problem. But it's all in the eye of the beholder. Some people will say, whenever I get a ruling that is not the way I like it, that's activism. When I get a ruling that is the way I like it, then that's judicial restraint. So there's going to be some perspective all the time. But the bottom line is we have to come to an agreement that when the legislators drafted a law and they used words, and the words have meanings, that I'm going to not go outside the regular definitions of those words, and I'm going to go outside that original intent. If I do, then I'm going to be activist. I'm going to be saying, well, that's not really what they meant. Can
you give an example at all off the top of your head? You've been in court. You're a judge. Can you give an example of where you might have seen that or it's been applied in some other case or a case?
Right. Judicial activism is...
I'm sorry to put you on the spot here, but...
No. There's lots of situations where judges will look at a law and somehow say, well, for some reason this law does not actually cover everything that needed to be covered. Maybe they feel that the legislature missed something. They didn't take into consideration this particular factual situation. So he or she, the judge, would look at it and say, well, I guess they didn't address it, so I guess I'm free to address it and basically decide what they would have done under those circumstances. Well, that's legislating from the bench. That's activism. That's something that's beyond the scope of what the courts are supposed to do. They're not supposed to, and this is really important for people to understand. Judges, courts, are simply supposed to apply the law to the facts. They're supposed to simply look at the facts, discern the truth, and then apply the law as it's clearly written to those facts. They're not supposed to be the determiners of right and wrong and truth and something that's not true. They are basically supposed to simply apply the law to the facts. That's why the founders, federally and I think on our state level as well, believed that the judicial branch was going to be the weakest branch. They wouldn't have the ability to necessarily tell everybody else what the Constitution means. They simply take the law and apply it to the facts.
So what would your suggestion, your thought be? You mentioned that a judge may be looking at a case and there's a gap in the suit or the dispute between these two parties, or whatever, it's individuals or corporations or groups or whatever. There's this gap, and the judge can't find a place to fill this gap in. If they're not going to be judicial activists, as you mentioned, what should their role be as a judge in a case like that, where there's this gaping hole in the process? Should they dismiss the case, refer it back to the legislature for review? Should they? I mean, if they're not supposed to be activists at the bench, what should they do?
Well, it's not so easy as to just say time out. We're going to stop the case and let the legislature create a law now to fill in the gaps, because you have two litigants that need resolution of their case. So that's the discretionary area. You're going to need men and women who are going to fill in those gaps. I guess the problem is going to be, how are you going to fill in those gaps? And if you are a person who is a conservative and does not want to expand beyond the statute, then you're going to interpret it one way. In other words, you want to have a judge who's not going to say, oh, this is an opportunity for me to go in a certain direction that clearly is not consistent with the legislative intent.